Hello, this is Alexander Cross, Criminal Defense here in the San Francisco Bay Area. If you'd like to learn more about criminal defense, don't forget to subscribe to our channel, Law Offices of Cross & Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos. So we received an interesting inquiry here on our YouTube channel. This has to do with somebody who got accused of a crime related to vehicles. Let's see here. My 17-year-old son, a minor, is being accused of stealing cars to dismantle them and sell the parts. Okay. Well, yeah, first of all, if you're taking cars, assuming we're not talking about carjacking, because, I mean, carjacking is when you're taking a car using force or fear, which would be a violation of Penal Code Section 215 here in the state of California that carries up to 9 years. So I'm going to assume that he wasn't taking these cars using force or fear. He was just basically, stealing the cars. Well, off the bat, obviously, if he's driving the vehicle without permission of the owner, that would be a felony under Vehicle Code Section 10851, which carries up to 3 years. Keep in mind, I'm not saying 3 years prison, because since he is a juvenile, this is going to go to juvenile court, and more likely any time he would have to serve would be at a juvenile detention facility. Now, let's say this minor, okay, so he's selling parts. Let's say he's selling the parts. Well, he may be caught, obviously, possession of stolen property. This would be a violation of Penal Code Section 496. If the value of the property that he is in possession of, that is stolen, is more than $950, that would be a felony that carries up to 3 years state prison as well. Now, this is something is really important to know. You don't actually have to be the one who stole the property. You don't have to be the one who actually stole the property for you to be charged with possession of stolen property. Simply being in possession of stolen property is enough. Now, the DA doesn't have to show that you actually knew that the property was stolen. If the DA could simply show that a reasonable person would believe that the property being sold is stolen, that is enough for you to be charged with a violation of Penal Code Section 496. Let me give you an example. Let's say, hypothetically, you're selling something at a flea market. Oh, I'm sorry, you're buying something at a flea market. Let's say you're buying something at a flea market, an iPhone, iPad, a 512 gigabyte iPad 2020. I don't know what model they have now, but let's say they're selling it brand new, sealed, for $1,500. And let's say it's a sealed, brand new Apple iPad, yada yada yada, and they're selling it to you for $200. Why? It's sealed, brand new. It's like, no, that should already raise you red flags. Why don't they just go to the store and return it? Worst case scenario, they would just have to pay the restocking fee of like 10% or whatever it is. But they'd get a lot more than $200. So there's got to be something there. So the point is, I mean, obviously, if it's property that it's not obviously stolen, if a reasonable person wouldn't believe it to be stolen, then you're not going to be charged with 496. However, there's another issue you got to factor in, which is what you spent on the property. Let's say, you bought property at a flea market, you weren't aware that it was stolen. You're not going to get your money back. The police will take the property. Let's say you're lucky enough not to get charged. You're not getting your money back. This happens all the time, for instance, with pawn shops, where they'll buy a stolen Rolex. Police will come in, say, hey buddy, this thing is it's stolen. Whatever they paid for that Rolex, pawn shop loses the money. They don't get reimbursed. So remember, it's a very huge risk buying stolen property, selling stolen property. For this minor here, more likely, because he is a minor, he's going to be convicted in juvenile court if in fact they have enough evidence against him. But you also have to bear in mind that in juvenile court there is no trial by jury. There is no jury. The judge decides 100%. It's trial by judge. The judge decides 100% if the minor is innocent or guilty in juvenile court. And unfortunately, for the defendant at least, in juvenile court there tend to be higher conviction rates, simply because you're not going to be able to sway a judge emotionally the way you would be able to potentially sway a jury. Regardless, if you'd like to learn more about criminal defense here in the San Francisco Bay Area, don't forget to subscribe to our channel, Law Offices of Cross & Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos. But If you've been accused of a crime and need representation in court, call us now for a free consultation at 1-800-862-7677. Once again, 1-800-862-7677. Criminal lawyer, criminal lawyers. DUI lawyer, DUI lawyers. Criminal attorney, criminal attorneys. DUI attorney, DUI attorneys.